Good afternoon and welcome to this webinar with Pragma Lawyers. This is the latest in our Legally Speaking series where we discuss topical issues in commercial law. My name is Mark Beyer, Senior Editor of Business News, and I'm joined today by Senior Associate Nick Malone and Special Counsel Lauren Evans, who specialises in property and real estate. Welcome to the two of you.
Thanks for having us.
Okay. Now today we've got about 4 topics we're going to run through. Statutory demands, personal guarantees, director penalty notices and ESG. So plenty to cover off there, and we've got about 30 minutes to run through these topics. So let's get into it. So look, let's start off by talking about statutory demands. Nick?
Yep.
Now let's, firstly, a little 101, what are we talking about with statutory demands? And then that'll lead us into a discussion about how they work, and in particular in the context of debt recovery.
Yeah, absolutely. So statutory demands are a really big part of the commercial enterprise of the Australian corporate legislature, if I can put it that way. And what I really mean in that sense is, well, what is a statutory demand and how do you use them? A statutory demand is a notice that's issued by a company or a creditor to a company, and it sets out why a debt they say is owed, and it's supported either by a judgment, so a court order, or by an affidavit setting out that the debt is owed and that there is no reasonable defence or arguable claim as to why the debt is not owed. And that is then issued to the receiving company's registered address, and that company then has 21 days in which to take action and do something about receipt of that demand. So the statutory demands for directors are really important to understand because they can have a significant effect on the solvency or presumption of solvency of the company they're a director of. And I'd always like to say with statutory demands that they're not overly onerous to issue, and you can sometimes find clients who are often directors of companies say, this company owes me money, why don't we just go issue a statutory demand? And you have to really walk them through, which we'll do in a moment, about, well, when is it appropriate to issue a statutory demand and when is it not? Because you don't want to be stuck in the Supreme Court down the road arguing about the legitimacy of why a statutory demand was issued if it's to be ultimately found that it wasn't issued on a reasonable basis.
So if you're someone wanting to issue a statutory demand, what's the threshold that you need to meet to make it legitimate?
Yeah, so there needs to be no reasonable or arguable claim that the debt is not owed, and the debt needs to be more than $4,000, and it needs to be owed by an entity, so a company. They're really the basic threshold to get over. If you can get over those hurdles, then it's a case of saying, well, strategically for my business at this time, is this the best thing I can do? Or is there another option I should be taking? So they're the minimum thresholds. When I say strategically, is it the best thing to utilise? The courts often say that statutory demands are not instruments for debt recovery. So merely because a debt is owed does not mean you should issue a statutory demand. It should really only be issued in those circumstances in which a company is insolvent or suspected to be insolvent. Mm-hmm. And it's a quick way that the courts can deal with insolvent companies without a creditor having to take that insolvent company through a legal proceeding, ultimately get to a judgment, and years go by. So it's supposed to be used as a very quick instrument to go from a company that is insolvent but continues to trade, to a presumption of insolvency, to then what's called a winding up application being made to the Supreme Court or the Federal Court, and then the court will wind up the company if you have done the things you need to do in the right order.
Okay.
So it's important to know because that presumption of insolvency is very important for directors.
Okay. So then if you're on the receiving end of a statutory demand, what are the options there? And I guess this question about whether you can negotiate a commercial settlement.
Yeah, for sure. So your options are pretty limited when you receive one. Option A is pay the debt, pay the amount sought. Now, typically parties don't choose that option because there is some reason that they haven't paid up until this point. But that is certainly one. The second is agree a settlement, and I'll come to that in a moment. But the third option is make an application to the Supreme Court or the Federal Court seeking to set aside that statutory demand. Now, the really important aspect to settlement and making this application is timeframe. If you want to make an application, you have to make it within 21 days of receiving the demand. That cannot be extended. So if you get a demand tomorrow, go see a lawyer tomorrow or go see a lawyer the next day.
Right.
Don't wait 20 days in and say, I got this 20 days ago. Oh, I dispute that the debt's owed and I don't really know what to do about it. I actually want to agree a settlement with them. Can you help me? Because the answer is going to be, it's going to cost you a lot of money to bring an application in a very short period of time. So the same applies for settlements. If you're going to settle a debt that is owed under a statutory demand, you want to make sure one of two things happens. Either the settlement is recorded in full and finalised within that 21-day period. And if that is the case, you want to ensure that the party who issued the statutory demand has in what's called open correspondence, so not on a without prejudice basis, which is typically the basis upon which you'll do the deal. So in open correspondence, the party who issued it has said that they withdraw the statutory demand, or you make the application to the court. When you make the application, the court will give you extra time until the next hearing date or a fixed date in the future. And that can then give you the extra time you need to do the deal. But what you shouldn't do is, within the 21-day period, seek to settle the matter, take no steps to protect your interest as a receiving party, and then on the 23rd day, try and do a deal. Because what you're going to find is the party who issued it, if they are litigious in nature, and they probably are if they're issuing statutory demands, will receive the advice from their lawyer. We've got the presumption of insolvency. We can go down to court and make the winding up application, and that might actually elicit more money out of this process. And the company who's sitting there saying, I'm trying to do a deal on the 23rd day, may not understand that there was a presumption of insolvency that already exists because they did not comply within the time. So in terms of making the application and that settlement, absolutely important to know timeframes. It's one of the very few areas of the law and commercial litigation where timeframes are so strict. Often, if you miss a deadline to file a witness statement or your statement of claim, you might get a bit of extra time and leniency from the court. But this is not one of those areas. And the reason is because the court does not have the power to grant the leniency if you try and make an application out of time.
Okay. And where people seek to set aside a statutory demand, does that happen very often?
It does, and there's a number of reasons why a party would.
Well, sorry, double question. When they seek to set it aside, and do they succeed in that very often?
Yeah, so it is factually dependent, and often they do, because the costs involved in setting aside an application are significant. It can typically cost somewhere between $10,000-$20,000 to set it aside because the urgency involved and the need to put on affidavit material which sets out the basis upon why you're seeking to set it aside. But if I just return to the basis upon which you can seek to set it aside, the often invoked defence is a genuine dispute. So if there's a court order, good luck trying to say there's a genuine dispute as to the debt owed. But if the statutory demand is supported by an affidavit, there may be a genuine dispute that money that's set out in the demand is actually owed or not. So that's the first basis. Secondly, an offsetting claim. So yeah, I owe them that money, but they owe me X amount, which is more than I owe them. And the trick with offsetting claims is to understand, if you get a statutory demand for $100,000 to your business, but you say that they owe you $80,000, that won't be enough typically to get the statutory demand set aside. The court may revise it to $20,000, or they may not, but they may revise it to $20,000 and say, but that amount is undisputed. So why shouldn't the demand stay on foot for that amount? You're now deemed insolvency. You go down that line. And then the third and fourth is there's a defect in the notice, in the demand itself. That's often used with parties who try and set them aside. Because of the strict compliance with the timeframes with statutory demands. There's also that, if I can put it this way, pressure put on the issuing party to ensure that their demand is in the right form. So you need to use a form 509H, which is a standard form, and that's not typically where parties go wrong. They typically go wrong by describing the party who's receiving the demand in the wrong way, so a typo in the name, using the wrong ACN of the company, using the wrong description of why the debt is owed if they're supporting it by an affidavit, those types of defects. And then fourthly, the court retains the power to set aside statutory demands for some other reason. And typically that's used if a statutory demand has been issued because there's a court order that supports it, and that court order is subject to a stay because that underlying proceeding is being appealed. That is some other reason in which the court may say, no, we're not going to allow this to continue. There is a stay of this judgment and there's an appeal on foot. That should be determined before you're allowed to enforce your rights. Okay. So they're the four reasons.
Right. You're a full bottle on this one, Nick. So anyone out there who needs some advice around statutory demands, great place to start here.
Feel free to contact us and let us know.
Yeah, and like many things, it seems to be down to the small details can bring people unstuck.
Especially with statutory demands. I cannot emphasise that enough. Yeah. Absolutely.
Okay, excellent. Thanks, Nick. Lauren, personal guarantees.
Yes.
So what are we talking about here? And how often do you see personal guarantees being called upon?
So personal guarantee, just as a very brief backstory to it, is a type of security that is often asked for from individuals where a company, for example, is entering into a contract, and it allows individuals to secure the company's obligations personally. So that is, for example, you have a company entering into a lease agreement, and the landlord's not comfortable that the company can secure their needs. So then the directors might be asked to give a guarantee, and that will bind the directors personally, and it will make them personally liable for any breach by the company of its obligations under the agreement. That then follows that should the company breach the agreement, the landlord or whoever the party is who is on the other side can go after those directors or any other person that might give a personal guarantee and go after their personal assets. So it doesn't need to be an asset of the company, it can be the family home. So it's definitely an area that people need to tread carefully, and an area that unfortunately a lot of people don't really understand when they're being asked for them, what they're agreeing to and what the risks involve.
Okay. And then one of the areas you talk about as well is when a director leaves a company and what sort of ongoing liability they have.
Yeah, so that's one thing that that people also aren't aware of. When a director leaves the company, if their personal guarantee, they've given a guarantee and they don't, they're not removed as a guarantor, that guarantee will continue on notwithstanding the fact that they're no longer a director. And I've seen this happen not necessarily just with directors. I've actually seen an employee, a very long-term employee of a company who agreed to give a personal guarantee. Went many years working for this company. It was all great. They had a fantastic relationship. She retired. Many years later, this guarantee was called upon. She'd forgotten she'd given it, but she'd never had that liability removed, and in the end had to remortgage her family home in order to pay out that guarantee.
That sounds like a horrific scenario.
It is a horrific scenario.
Particularly for an employee.
Particularly for an employee, and it's a really unfortunate scenario. So certainly you don't see it very often that employees are the ones giving these guarantees. It's more likely that the directors, the people in charge of a company, are the ones who do give those guarantees. But it is still a risk for them that if they leave the company, that they still have that there. Now, you could have...
So, and just on that,
yes.
Is it typically where they're just a little bit careless in tidying up loose ends when they leave? That people aren't aware of this requirement to remove it?
It's that, but I think it's also not really understanding what they've entered into to start with. And the fact that I have a lot of leasing clients that will come to me, give me a lease that their landlord has prepared, and it will include in it a personal guarantee, and they don't think anything of it. They think, well, this is normal. The landlord has it as part of their standard document. We'll just sign it. We'll also give them a bank guarantee, which is another document that they've requested in there. And what they don't understand is that firstly, they don't need to give multiple forms of security, and that this is a point that can be negotiated. But also that by doing that, they are binding their own personal assets and putting all of that at risk. So I have had a matter where it was a couple who were both directors at the company. One of the directors was put down as a guarantor, and the other one insisted that she was also guarantor. And that just goes to people not understanding the risk that comes with being a guarantor. Generally speaking, these personal guarantee clauses in contracts allow the party who's claiming over them, so in my case with leasing, the landlord, it allows them to go after the guarantor without needing to go after the tenant first. So it doesn't matter if the tenant is able to somehow rectify the default and pay out whatever money is owing, they have an entitlement to go straight to the jugular for these personal guarantors. So in that, it's very important with asset protection to really consider that if you do have to give a personal guarantee, it's important to think about who is giving the guarantee and what assets they have that are at risk from giving the guarantee, and whether there is a way of protecting those assets. So very important, particularly because in the case of director guarantors, they've set up a company to run their business, and one part of having a company to run a business is that a director is afforded some protection through the corporate veil for their personal assets. By agreeing to sign a personal guarantee, they're essentially bypassing and undoing that protection and saying, despite the fact that we've got this company and we have a separate entity that we're running our business through, you can still have at me. So it's a real risky area.
And where a director leaves a company, what are the options there? Because I guess they could just ensure that they're removed from providing that guarantee. But you also talk about the scenario where they get an indemnity from continuing directors,
yes,
which isn't always what it might appear to be.
That's right. So obviously there is the option of being removed as a guarantor, which is the best way of doing things. But also you could have an indemnity like you've suggested. So that is where the continuing, so in the circumstances that you have two directors, one of them's decided, I want to retire, I want to move on for whatever reason, I'm going to sell out of my business. They could get an indemnity from the continuing director that if for whatever reason in the future that personal guarantee that the outgoing director has signed and agreed to is called upon, then the continuing director will cover them, that they will indemnify them for any loss. So essentially that continuing director will pay up instead of the guarantor director who's left. Now it's really only worth what that continuing director's worth. So if the continuing director doesn't have any assets, they can give you a liability, an indemnity, but if they can't pay out and they can't back up that indemnity, you're still liable. So again, it's just best to get out of them as much as you can and make sure that all of those loose ends are tied up when you're moving on.
Okay, very good. Thanks, Lauren. Some more good advice there on that one. Now, Nick, next topic, director penalty notices.
It is. And if I could say one thing on the personal guarantee front as well, because we do a lot of insolvency work at Pragma. One thing that when directors come in to see us that we often ask is, well, have you given any personal guarantees? And the thing they say is, well, yes, but they don't really know. So if you're a director out there, try and understand what have you given a personal guarantee for, check your contracts and try and keep a register or something like it. Because as Lauren says, when you want to leave the business, it's important to know which relationships you need to go and unwind so that you can get out clean.
Okay.
And this leads us into director penalty notices in a nice way because, as Lauren says, a guarantee can pierce the corporate veil, as can director penalty notices. But before we get into the substance of it, maybe it's good to start with, well, what are they? They're issued by the ATO to recover debts that the company owes from its directors. So the three examples that the ATO may issue director penalty notices for is PYOG withholding. So if you have not paid that as the company, that may be a basis upon which a DPN will be issued. The second is net GST, so if you haven't remitted the GST. And then thirdly is this superannuation guarantee charge. So there's pretty obvious public policy reasons as to why those three are put back onto the directors, which is to say, pay your people, pay them on time, and make sure that you're up to date with your taxes. Mm-hmm. Because if you're not, we'll come after you, because the Australian taxpayer as a society doesn't want to be holding the basket for all of these amounts. And you would have seen in the last couple of days, one of the large building companies over east that went under had millions of dollars of outstanding superannuation payments to their own employees, and the government will pick up that tab. So the government does have that mechanism there, but where it picks it up, it then will go after the directors and try and recover it. So that's what a director penalty notice is issued in relation to. Mm-hmm. But I guess the real question is, well, how do I know if I get one? And what do they look like? And they look very similar, will have a similar effect to a statutory demand in a funny way. That they'll look like a document from the ATO, but typically a director penalty notice will give you 21 days to rectify the default. So if the company owes an outstanding tax liability, you've got 21 days to pay it. If, for whatever reason, the company doesn't want to or cannot pay it, the director has a limited amount of options available to them, and they all centre upon put the company into external administration. So it's very serious as to what to do in that 21-day period. Either, as a director, you've got to figure out, is this something we can pay and we can afford to pay? And if not, what steps are we taking to put the company into external administration? Mm-hmm. Because if you don't do that within the 21-day period, you'll be personally liable. And then it becomes you take the power out of your own hands, and then it's up to the ATO as to what step they wish to take next.
Okay. What if you're a non-executive director? You're not involved in the day-to-day running of the company. Does that give you an out here?
Yeah, so this is a classic one that you see similar to personal guarantees. You know, I gave a guarantee, but I'm not really involved in the business. And the answer is absolutely not. Absolutely not. The only way that you can get around or out of liability for a director penalty notice is if you're ill at the relevant time that debt was incurred, or there is some other reason as to why you could not or should not be liable for it. But the answer that I'm a non-executive director is not good enough. And in fact, what the courts have said when this type of argument has been raised is, we don't care whether you're executive or non-executive. You are a director, you're an office holder, and you've got obligations under the Corporations Act. And you should be aware of what those obligations are, and you should be discharging them at all times. So if you do not know what taxation liabilities the company that you're a director of has, you're probably going to be in contravention of your Section 180 or 184 director duties. Because it's not good enough to say, I'm leaving it to Lauren, she can run the business, I'm just out here taking all the money. Mm-hmm. When she issues me with director, when she gives me a director dividend or whatever the case may be. No. If you're an office holder, you're an office holder.
Yeah, okay. So ask lots of questions.
Absolutely.
Across it.
Absolutely. And it's the same sort of thing with statutory demands. You can't extend the deadline, so that's not possible. Recent case law also says that if you enter into a payment plan, so if the company enters into a payment plan, that doesn't alleviate all the issues. So a big thing is make sure that you've taken the steps you need to as a director, and unfortunately, typically that means get advice and get it early. In what we do, especially in the insolvency space, the earlier people come and see us, the better the outcome usually is for them. If you see us on the death knell of the company, or when you've already incurred this massive personal liability as a director, there's very little professional advisors can do for you. Whereas if you come earlier, there's a better chance you can get a better result.
Okay, good. Okay, so we've covered off all on that one?
I think so.
Yep, okay. Our fourth topic and final topic for this webinar is ESG. So that's the catch-all phrase that's being used increasingly for environmental, social and governance issues. We're hearing a lot more about it, aren't we, Lauren?
We certainly are.
The question many people ask is, okay, what does this actually mean for my business? What are the things I need to be focused on here?
That's right. So the ESGs have stemmed from the UN Sustainable Development Goals, which are basically focused on ending poverty, improving education, reducing inequality and spurring business growth while also tackling climate change. So it's a really big area. But it's one that there's a growing movement across the globe, and it is not just in business. This is consumers, this is investors. Everyone's looking towards sustainable business, and they're looking and asking more questions about how products have come to life and what's going on behind the front that you generally see. So for businesses in Australia, there's no mandatory reporting requirements at the moment. However, the ASX has recommended that ASX listed companies report against certain environmental and social risks. So that at the moment it's ASX listed companies that pretty much need to, even though there's no mandatory reporting requirement. It's really very strongly recommended. However, it's recommended that all companies look at this. And there's a reason why. There's several reasons why. Firstly, directors have responsibilities under the Corporations Act. Of course, they know that. And one of those responsibilities is under Section 180 of the Corporations Act. And that says that directors must exercise their powers and duties with the degree of care and diligence that a reasonable person would if they're in the same position with the same company in the same circumstances. So it's really important for directors to consider the impact of things like climate change on the future of their business and how that might impact their operations and all sorts. So for example, if there's supply chain disruptions in the case of extreme weather events, which we're seeing more and more of lately, and there's been no forward planning as to what the company will do in that event, the director could actually be held in breach of their responsibility to exercise care and diligence in relation to that. So it is something that directors really do need to start looking at. And there could, of course, be real consequences for the business, as we've seen with products not being available on our shelves with COVID. There are things happening out there that we need to account for and plan for. And in sitting down and planning these and working out what our risks are across the business as a whole, it also gives us the opportunity to make our business better. Now, the other key reason why you would be interested in looking into ESGs and applying these principles to your business and setting up a framework to work to and to implement across the board is because investors and consumers are more looking at where they want to spend their money. So at the ground level, you have people who now want to buy makeup, for example, and are looking at whether the products have been tested on animals, whether they're vegan, all sorts of different things, whether there's any modern slavery in the supply line. So we've got educated consumers who are asking questions, and companies need to respond to those in order to stay relevant and on top of things, but not just for their own business and success, but because it's very likely in the near future that these will be real mandatory reporting requirements.
So to take one of these examples, and I know this is sort of a fast-moving area, but supply chain, how far should a company director go to try and verify that they have a sustainable supply chain and in fact there isn't slavery sort of down the supply chain somewhere?
Well, a good director should know all about their business. They've got this requirement to know, and so they should be aware of the start, I suppose, of their product, and make investigations themselves, and if anything seems a bit fishy, to ask more questions, because ultimately that's what the investors are doing, that's what the consumers are doing, and that's what the reporting bodies will be doing as well. So in getting on top of it now and ensuring that everything is above board and there is no modern slavery, for example, at the outset now, they can be comfortable moving forward that they've got a good base, and it's a case of ensuring that continues rather than being investigated and having to scramble and go backwards.
Because I know some of the regulators, like ASIC in particular, has been quite vocal in this area, and their concern is about companies using greenwashing,
Yes.
making unreasonable claims about the sustainability of their business.
I think one thing for directors to understand when they're making these sorts of claims, because especially it's such a hot topic now, directors want to make these claims because they think it makes their business look better. The one thing they've really got to understand is, am I being misleading or deceptive of what I'm doing? Those legislative provisions don't go away merely because we're dealing about an ESG issue. And businesses, Lauren's right, consumers are all looking at it saying, what is this company doing in the ESG space? What are the claims they're making? And are they legitimate? And as a director, making sure that you can back up your ESG claims is going to be vitally important, if for nothing else than a social licence, especially for those bigger entities in the future.
Okay. And having looked at some listed companies, they produce numerous indicators of their ESG performance. I suppose for most businesses, and particularly smaller ones, it's a question of asking, well, what's really important for our business? Because you can't tick off every possible indicator. They should be really focused on what's relevant to them.
Yeah, absolutely. And there are resources out there which look at different industries and have specific areas to look at and focus on for different industries. But ultimately, I think if you can go back to the UN Sustainability Development Goals, that's the overarching aim of all of it. So it's a case of sitting down, assessing your business and the areas of risk relating to those goals, and the rest of your business while you're at it, and developing a framework that works for your business and that you can implement from the top down and actually implement this framework. Don't just have a one-page document that you can put on your website and say, oh, we've got an ESG, that actually takes steps that you can measure and report against in the future as well, or even voluntarily report against in your reports. Yeah.
Okay. And last question on this one, is it valid to sort of compare it to, say, the ASX corporate governance guidelines, where there's sort of a best practice guidelines, and a company can actually put in their annual report, we don't comply with this guideline, and this is why, because our circumstances make that not appropriate. And I assume across ESG, it could be similar.
Absolutely. And I think what we'll find is more companies doing that. And more companies voluntarily putting it in their reports and explaining why they're doing so. I'm always a bit sceptical when it's people, when it's a non-mandatory aspect of reporting, them putting in a statement that they're not reporting against it. Typically, naivety is the way they'll go down, or just leaving that over there, head in the sand. Let's not worry about it. But I think as demand grows, especially from institutional investors and consumers, companies will have to start reporting on this, whether it's legislatively required or not. And you're right, I think it'll be very similar to those sort of ASX guidelines.
Okay, very good. Okay, thank you very much.
Thanks, Mark.
Appreciate the time. Okay, look, this webinar will shortly be uploaded to the Pragma website. That's simply pragma.law. So if you'd like to go back and have another look and review some of this content, or if there are things here that you think a colleague or friend might find useful, you can refer it to them, or give Pragma a call at their Subiaco offices and get more detail. So Nick and Lauren, thank you very much.
Thank you.